Hello, everybody. My name is Zan Dalio. I'm filling in for Joe Brew today. This is my first time hosting. So welcome to Feminist Question Time. It's brought to you by the Women's Declaration International, the leading global organization defending women's sex-based rights against threats posed to gender identity ideology. There is more information on our website, womensdeclaration.com, where you'll find our declaration on women's sex-based rights. Please do check it out if you haven't. We have, as of yesterday, 37,832 people from 160 countries as signatories, and we are supported by 523 organizations. We have a lot of volunteer activists, including country contacts from every continent. So please join us. You can become a member, you can volunteer, or you can also donate. Get in touch with us at info@womensdeclaration.com or via your country contact on the website. Our three speakers are Megan Blake from Australia. She's going to be reporting on the Tickle versus Giggle case. Then we have Gabriella from Ireland. She's going to be giving us an update. And then later on, Joe is going to be coming in live from a conference in London, I believe, and she's going to be talking to Sally Wainwright from Scotland, giving us an update. I'd like to introduce Megan. Megan Blake has a degree in law from the University of Melbourne and a PhD from Monash University. She has worked in policy, research, and project management, and has taught at secondary and tertiary levels. Megan's advocacy and volunteer work has focused on women's rights and refugee support, and she's currently working with the Feminist Legal Clinic in its representation of the Lesbian Action Group regarding application for a single-sex exemption under the Sex Discrimination Act 1984. She's going to be talking to us about the very hot and very interesting Tickle versus Giggle case. What happened? What does it mean? And how does it relate to CEDAW? So welcome, Megan. Thanks for joining us from Australia.
So the Tickle and Giggle case is kind of like the app against the chap. Before I go into the facts of the case, I know that we have an audience coming from many different countries. So just a little bit about the Australian context. So Australia is a federation, which means we have a national parliament, but then we also have state parliaments. So each has its own laws and areas of lawmaking. So the only proviso really is that state law that is entirely incompatible with federal law will be invalid to that extent. States have mostly plenary powers, though. They were the original colonies. So the federal parliament can only legislate on matters given to it at federation in the Constitution. Now, of course, sex-based rights were not given in the Constitution. So the power to implement treaty obligations is, however, given to it in the Constitution. And a treaty is not law domestically in Australia, even when ratified, unless the national parliament legislates on it, and it can pick and choose the parts of the treaty that it wants to implement. So Australia signed CEDAW in 1983, and it passed the Sex Discrimination Act, which I was called the SDA, in 1984 to implement it. So that's the piece of legislation that Tickle and Giggle is challenging in a way. And that is also the piece of legislation that the Lesbian Action Group matter coming up in September will also be regarding. And it really is, if it's the Sex Discrimination Act, what is sex? Like, that's the case. We also knew what transsexuals were, and yet we decided not to include them. So that changed pretty quickly. So Sal Grover launched an app in 2020. It was designed for women only for activities such as lesbian dating, finding housemates, chatting, no dick pics. So it was deliberately discriminatory in onboarding. It used facial recognition AI and visual inspection of selfies to make sure that the AI was filtering correctly. So that was part of its design. So a man called Roxy Tickle, who claims to have been living as a woman since 2017, gained access to it through the selfie, but was removed afterwards and then complained multiple times via email and Sal's mobile. He didn't get a response other than one single fairly pro forma email reply that his complaint would be looked into. So he launched action against Sal and Giggle for discrimination. It went to the Human Rights Commission first, and now it's in the federal court. So these legal proceedings triggered public commentary, memes, mockery, products such as on Etsy, a scented candle in his honor that riffed on something he said during an interview. And it printed a cartoon dialogue box on the candle that said, so I realized I was a woman because I hate the smell of bowls. Bowls, hate them. I had to get away from smelly bowls. So Candlegate actually occurred during trial when counsel for Tickle, when cross-examining Sal, very suddenly, with no warning, turned to her and said something like, I put before you a picture of the smelly balls team Giggle scented soy candle. And then we had the great Jacques moment where counsel pointed her finger at Sal and went, are you laughing? I mean, everyone in the court was a little bit. So yes, Roxy has been the subject of public critique since he launched the action against Sal. So the participants in the case, so we've got Tickle, represented by a firm pro bono, and he has a public grant of $50,000 for a costs guarantee. Then we have Sal Grover and Giggle for Girls, two respondents, and they're paying full fee private representation. We've got the Human Rights Commission, the Australian Federal Human Rights Commission, and they're intervening on behalf of the Sex Discrimination Commissioner, and their submission supports Tickle. And then the judge is Justice Bromwich. He's former Commonwealth kind of DPP, Department of Public Prosecutions, criminal law. He's very well regarded. He's a great judge. So got a good pick on the judges.
And who did they exclude?
That's interesting. So we had two other parties asking to intervene. We had Reem Al Salam, so special rapporteur, and we also had the Feminist Legal Clinic, which is now the only expressly female-only legal clinic left in Australia. And they both applied to intervene, and they would have given submissions more in support of Giggle's side, but Giggle actually and Tickle, I understand, both parties opposed their intervention, so Bromwich refused. So we just had the Human Rights Commission, which is also interesting from the perspective of future cases, because of course the Lesbian Action Group case is directly against the Human Rights Commission. So it's nice to see their arguments first and maybe prepare for them, but we'll have to see what the outcome of this case is. So in terms of the opposing cases, I will sometimes use words like trans woman, cis, gender identity as though it's something that exists. And I know that's not language that the audience agrees with, but it's really just to kind of communicate the arguments on each side. So I just want to say that first. So the Tickle case has a premise that the SDA defines sex as a social and psychological category, not a biological one. And therefore, it's determined by someone's gender identity. So the premise is that this is supported by the current meaning, the current interpretation of CEDAW. So they're making two claims against Sal and Giggle. The first one is indirect discrimination. So the idea is that Giggle discriminated against men, but that's okay. So the problem is that by applying the sex categories biologically, they indirectly discriminated on the basis of gender identity by including trans women in the category of cis men, like sweeping them up unfairly. Or in the alternative, because it has to be one or the other, that it was direct discrimination. So that Sal and Giggle directly discriminated against Tickle on the basis of his gender identity by refusing service to him because he was a trans woman, and that they knew that. So one or the other. Now, the Giggle case didn't have kind of like an order of we argue this, however, in the alternative. So I've kind of synthesized it into what I think are the 5 main defenses, but these are coming from me. So you might read the transcript and have a different synthesis. But I think that the first defense is that Tickle was excluded purely on the basis of his male sex and gender identity was irrelevant. Therefore, there's no direct discrimination. 2, that if you apply and interpret it properly, the SDA protects women as a biological sex class. Therefore, there's no indirect discrimination because an internal gender identity doesn't alter the composition of or cause men to overlap with the sex class of women. 3, that gender identity, kind of like from the start, ab initio, is not a concept that can or should be enforced at law. It's too amorphous and based on stereotypes. 4, that the SDA is only valid if it implements CEDAW and that CEDAW does not define sex by gender identity, so directly in opposition with the AHRC's claim and Tickle's claim. And then the last one is that if the SDA is in fact bound to protect biological sex under CEDAW, then state laws defining sex by gender identity must be invalid to some extent. And that, of course, for Australia is important because every single state and territory in Australia defines sex largely by gender identity. We have a few kind of, you must have a medical procedure, but by and large, every reference to sex in our legislation is a reference to self-identified sex identity. You've got a number of questions in the case. So you've got your factual issues and then you have your legal issues. Now, of course, the factual issues could determine the case. In one sense, this would be a disappointing outcome because the legal questions are so urgent. If it's determined on a factual issue, that's not going to move the law at all. So that's not going to really set precedent. But on the other hand, that would also stop an undesirable precedent from being set on the law. So we don't know how Bromwich is going to go. But they're just questions like, is the app a trading corporation? Did Sal receive the emails and therefore deliberately fail to respond to them? If she did fail, was it for reasons of his gender identity? Has he in fact been, living as a woman, shopping on this particular side of Kmart or Target versus that side came up multiple times across the 3 days? Are the public tweets Sal's responsibility in the sense that they can aggravate the damages payable to Tickle? So it's, can you aggravate your damages simply by continuing to call a man if he's suing you for calling him a man?
Well, let me ask you a question because I was following the tribunal tweets on the second day, and there was from Tickle's side this line of argument questioning about kindness was Sal. Where does that? I mean, I was like, what? How does kindness? Is this a factual thing? What is kindness?
Look, I'm not sure. I'm not sure whether, so no, the Tickle's counsel did literally ask Sal under cross-examination, do you think this is kind?
I know.
And you're like,
I'm like, what? I mean, give me a,
who cares?
I know, but that's what I really wanted to find out. Where's the legal, what's legally up? Yeah. Why are we asking that question? What's the motivation?
I think it goes to 2 things. Look, it wasn't spelled out really expressly, but I think that they asked that because it goes to 2 things in their eyes. I think the first thing it goes to is this idea of direct discrimination, deliberately excluding or refusing service to him. And so if you're willing to be unkind to him by refusing to call him a woman, refusing to call him she, then it suggests maybe that direct discrimination was more likely. So I think that was half of what they were trying to get across. But the other half is, of course, the aggravated damages claim. So he's asked for $100,000 in base compensation and $100,000 in aggravated damages. And there was a lot of time spent on, Sal basically just being a meanie and supporting mean things.
Yeah.
And I think that a big part of that was potentially trying to emotionally position the hearing as a mean woman against a
Right.
poor trans woman, because also, Sal is an attractive woman. She's a very good speaker. Tickle is a very unattractive man, and he's not a particularly good speaker. So you do have, if you just look at it from, the optics, you do have that kind of imbalance. And I think that they might have been trying to play that a little bit. It's like, look at this woman who's like making this poor guy, trans woman, feel bad. I feel like that might have been a little bit of it as well.
Oh yeah. I mean, and there's the moral, the moral flavor of it is just, ooh, witch hunt, I
Well,
mean,
her first question, what her first, so when I say sorry, her, I
Starvo.
mean counsel for Tickle. Yeah. So counsel for Tickle, her first line of questioning to Sal under cross-examination was actually asking Sal to confirm that Tickle did in fact shop in the women's section. She's like, I don't
Yeah.
know where he shops. How am I supposed to know where he shops? And then asking her to confirm that he did in fact have his penis chopped off and have genital surgery. She's like, I don't know whether he's had genital surgery.
Yeah.
So it was really, and then it was, this, and then of course that particular line of questioning that I think has traveled over the internet a lot in kind of 2 days, where she said, I put it to you that if a person, assigned male at birth, shops in the women's section, spends money getting hair removed, goes by a female name, wears women's clothing, goes into women's change rooms, I put it to you that you still don't think that that person is a woman. And she
Yeah.
said, no.
Yeah.
She was very, very good under cross-examination. A lot of witnesses, especially if they feel aggrieved, they want to jump in and answer and clarify and argue back. And it's really hard not to, but a lot of the time it's not in your best interests. So I think she did just a fantastic job under cross-examination. Just to go to, I guess, the legal issues, because this is where, CEDAW starts to come in as well. I've again, this is my synthesis. I've identified, like the top 10 that I think are being asked here. So the first one, what does sex mean in the Sex Discrimination Act? And then two, what does gender identity mean in the Sex Discrimination Act? Because sex is not defined in the Sex Discrimination Act. Gender identity is, but it's a circular definition. So it's gender identity are the gender related presentations and mannerisms and appearances. Like it's very circular. It's not a clear definition. So those are the first two questions. The third one is kind of a connection. Like, therefore, what is the relationship between sex and gender identity? And do they just necessarily overlap and create a de facto hierarchy of protected attributes where only one can be protected at a time, or are they different in some way and can both be protected, at the same time? So, question 4, can you have a special measure that discriminates against men for the benefit of women to achieve substantive equality if that special measure treats sex as biological and then requires discrimination on the basis of another protected attribute, gender identity? Like, is that acceptable? 5, is gender identity something that can be articulated clearly and enforced at law in any kind of consistent, logical way? 6, does determining sex by reference to gender identity still achieve the purposes of the SDA? 7, do sex and woman in CEDAW now include men who claim a female gender identity? 8, connected to that, where do we look for authoritative guidance on that? Where should we tell Justice Bromwich to look for authoritative guidance on that? So it was discussed in court that the committee was more authoritative than third-party commentators. But what if the committee comments themselves, as they are, I would submit, are a bit mixed or ambiguous? Do we ignore committee comments if we believe they fail to achieve the obligations under the convention? 9, I guess, more Australia relevant. If we do presume to be able to change the meaning of international instruments by reference to, jurisprudence and committee commentary, are there limits on the additional powers the national parliament can get as a result of this process? Because in Australia, the national parliament, has that power to pass laws that implement treaty obligations. If we interpret treaty obligations radically differently over time, does this just give the national parliament infinitely changeable powers? And then lastly, that question of if federal law is in fact limited to the protection of biological sex and cannot replace it entirely with sex identity, are state laws that do replace it inconsistent to some extent and therefore invalid? So kind of those are I think, the legal questions that come through the case. We don't, of course, know how many of those will be addressed in the judgment because, it could be decided on some very narrow factual claim and the legal questions avoided. Sometimes courts do that. I wish I had a read on what Bromwich would do, but it was a very wide-ranging kind of argument, and he has lots of options about the direction that he can go in.
Which is kind of good in a way, isn't it?
Yeah. Yeah, especially when you have a lot of confidence in the court and the judge. I think that is good. If you have very narrow legal arguments and you marshal them well, the judge has less room to move, and that can be good in some cases. But I do think this particular issue maybe benefits from being left open a little bit. Look, I guess we'll see. 6 weeks to 6 months, I reckon, as the outside frame. I guess 2 things that I kind of wanted to bring up as questions that I wish had come out more in the case that I think now we need to do a little bit of further work on. So the first one is the question of the comparator. So under federal law in Australia, to prove discrimination, you need to identify the appropriate comparator. So the comparator is the person who has the same material features as you, other than like the one you believe were discriminated against. And you show that your comparator received better treatment than you did, ergo, it must be because of the one feature that you took out. So in Australia, the comparator for a trans woman is assumed to be a cis woman. But I question this on its own merits. Yeah. So outside my critique, I question it on its own merits. And I really wish it had been challenged. Because according to transgender ideology itself, the thing that shifts a man from the male sex class to the female sex class is his gender identity. So if you remove his gender identity to find the person who's materially the same otherwise, you are left with a man. Your comparator, I don't think is necessarily the group that you want to be associated with your protected attribute. It's the group you would belong to without it. The comparator for a pregnant woman is not like a pregnant man. It's a non-pregnant woman. Like you've kind of got to take the right one out.
Yeah.
But that was just accepted that, okay, that is the comparator. And I would like that to be teased out a little bit more. Another question that was kind of implied in the arguments, but I don't think it was addressed as directly as I had hoped from any party, including the Human Rights Commission, was why one interpretation of CEDAW should be favoured over another. Because, we have the AHRC's interpretation, which is that the committee has made comments that do include men in the protection category of the convention by virtue of their claimed gender identity. Australia, for instance, is still labouring under the 2018 recommendation in response to our last progress report that we allow men in New South Wales to self-identify into an altered birth certificate, and that we're in breach of CEDAW obligations if we don't do that. So these are the kinds of comments that the AHRC and therefore Tickle relied on to show that CEDAW does include men claiming to be women in its ambit and that it now defines sex by sex identity. But then we have Giggle's interpretation, which was substantially identical with Reem Al-Salem's position paper, because the paper was read verbally into Giggle's closing submissions, kind of in lieu of their own arguments on CEDAW. And just like the AHRC, I thought it kind of didn't really deal with examples from the committee that didn't fit their interpretation. So I don't think that, so instead of both sides arguing or acknowledging the factual validity of points on the other side, and then directly addressing why their position is the stronger one on textual grounds, purposive grounds, and policy grounds, it was a little bit more, this is what the committee says, they don't say that. And then on the other side, no, this is what the committee says, they don't say that. And, I think that if we look at a lot of the commentary, they say a range of things on both sides and it's not clear. And so I really want to look at those two competing arguments of interpretation. Do we adhere as closely as possible to the, original or intended meaning? Because that will sometimes best achieve the purpose of that law and positive policy outcomes. But, on the other side, sometimes we actually do want to evolve a meaning over time because the views and needs of society will sometimes change. And so this will be the better way of achieving that. And I think both approaches are valid, but it depends on the facts of each case. Australia, for instance, evolved the meaning of two-way communication devices, such as telegraphs and telephones in the Constitution, to also include one-way broadcast devices, such as radios and TVs. So, this was a living tree approach, and it was arguably right for that context. But is it right for the meaning of sex in CEDAW and the SDA, or will a living tree approach actually undermine the purpose rather than kind of keep it contemporary? And now I have an opinion on this, of course. I think it's probably the same as yours. But that doesn't mean the other approach is invalid in principle. So I just don't think it works in this case. And Justice Bromwich tried to engage the parties on this, but it kind of never really came out clearly. It was more, this is what CEDAW covers, as opposed to, okay, well, CEDAW could cover these competing options, but this is why I think CEDAW should cover this one of them instead of the other. And I think we need to do that because I don't think it works to convince the other side as much. So I guess that was my those 2 points. I really walked away from the case wanting to find a way to tease those two out a little bit more. So sorry, I'm not really watching the chat, but I just saw someone say a living tree approach with a question mark. So that's just, I guess, a shorthand for the approach to interpretation that evolves the meaning of words over time, as opposed to a more originalist textual approach. So, sometimes in law, the living tree approach will be the best way to achieve the purpose of the law and the policy objectives. Otherwise, the law just becomes out of date and irrelevant. Mm-hmm. Other times in law, you don't want to do that because it actually takes law away from what it's trying to achieve in the first place. It undermines it.
Yeah.
And I think we need to be able to articulate why.
Yeah, and I mean,
and I know women do. Sorry, I don't mean to be. I'm not saying that women don't across the world. I know that women do. In this case, I found that something I wanted more of, I guess I would say. As ridiculous as it feels, arguing things that seem patently obvious, unfortunately, when the other side doesn't think it's patently obvious, and when the other side is in charge of deciding what the law is,
no, I totally hear you on that. I totally get that from the standpoint of the legalities of it. But and at the same time, I mean, with this concept of gender identity, really, got roots now. It's not just floating around. It's got really serious implications, the roots of it. How then this idea of sex, you know what I mean? I mean, I don't know. It just
And
means
there are people who are opportunists and don't genuinely believe that protecting gender identity is the most effective way of, protecting whatever they think they're protecting. I know there are definitely bad actors out there, but there are people who are well intentioned and have somehow come to the conclusion that this is the best way of protecting society. And those are the people that I'm most interested in talking to, because the bad actors and the perverts and the fetishists, not my target audience. So I'm more interested in the people who do think that what they're doing, what they're supporting, is genuinely the right way to protect women, however they conceive of women. And I really want to, talk to those people and really argue why that is misconceived. Was Tickle required to be called she in proceedings? And it wasn't addressed in this particular hearing. So his counsel asked the judge for an order that he be called she in cross-examination of him, but that wasn't opposed by Giggle, but then they chose not to cross-examine him, so no order was made regarding it. The judge did refer to Ms. and she. In Australia, it's left up to, or in Victoria in particular, it's left up to the discretion of each individual judge, and they can make an order saying yes. A lot of the time, I have to be honest, it's a strategic decision to do it, because, you're worried in court about uh, about looking in contempt, looking like you're trying to be disrespectful, maybe jeopardizing the case for your client. But then you have to balance that against the exact principle that you're trying to stand for and trying to protect. So Sal said Ms. Tickle. She wasn't ordered to, but she did. But she also said he. So she used a combination. Counsel for Sal, I think, just kind of tried to avoid it entirely, honestly. Said is a man, is a biological man, but just I think sometimes it's easier just taking the pronouns out. But yeah, no order was made. It could have been made though, and Bromwich is able to decide either way. Biological sex is no longer a protected class. The gender identity argument is interesting. There's kind of an underlying assumption in Australian law that every person does have a gender identity. There's no real option for someone not having one. But the way that the law plays out, it seems to kind of go along these lines. We have a legal sex class of women. Within the legal sex class of women, we have women with a gender identity of cis woman, and we have women with a gender identity of trans woman. So they're men. So that's the sex class of women. And then you either have the gender identity of cis or you have the gender identity of trans. And that's based on what your underlying body was assigned as at birth. So the discrimination wasn't against anyone with a gender identity. The discrimination alleged was against any woman legally with the specific gender identity of trans.
Could the decision in Sappho's party case 2008 affect Justice Bromwich's decision in this case? I asked because it was ruled that Sappho's was a private event, and so the man IDing as a woman could not claim discrimination. And I asked because Sal's Giggle app is a private business. Would this help his decision?
Yeah, unfortunately, there is a permanent exemption in the Act for private membership-based clubs. So if it's a membership-based club, then it can, but the app doesn't come under the exact definition of a membership-based club. It's a company service provided to the general public, as opposed to a club. So
Right.
yeah, like clubs have like the membership fee and the constitution, and it's just a slightly different legal structure. Yeah, unfortunately, there was argument over whether it was a trading corporation for the purposes of the constitution to kind of back up the SDA if CEDAW fell. But that was the only discussion in that. Sorry, I did actually just want to say, if any woman on the chat or listening to the webinar knows of cases, particularly from other countries, where courts have grappled with some of these same questions, like the top 10 legal issues that I went through before, that would be really helpful. We'd love to hear about those, because we don't really know so much about internally within other countries where the courts have looked at what the meaning of sex now is in CEDAW according to their internal domestic judgment, what materials they relied on as more authoritative, what materials less authoritative. So that kind of jurisprudence would be really beneficial if anyone had knowledge of those kinds of things.
We'll move on to Gabriella from Ireland. She's going to be giving us an update on what's going on in Ireland.
Just over a month ago on International Women's Day, the government held 2 referenda. And just to give a quick background, so here in Ireland, we have a constitution that can only be amended by approval of the people by vote. So this is why Ireland has so many referendums. So the most recent high profile ones being marriage equality in 2015 and then abortion in 2018. So these recent referendums were to amend articles on the definition of the family and on the provision of care. And despite all major political parties, including the opposition and the vast majority of NGOs supporting these amendments, both of them failed. So the first one was called the Family Amendment. That planned to change the definition of the family from the marital unit to being founded on, quote, marriage or other durable relationships. And 66.9% of people voted against this one. And then the second one, which I'm going to talk about a bit more, is about the role of women and mothers and care. So for this referendum, the government proposed to delete Article 41.2 of the Constitution, which says, the state recognizes that by her life in the home, woman gives to the state a support without which the common good cannot be achieved. The state therefore shall endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of her duties in the home. So this article would be replaced with a gender-neutral article recognising the provision of cares by members of a family to one another, and stated that the government would strive to support such provision. So this one was defeated by a massive margin. 73.9% people voted against this amendment, and this was the biggest failure in a referendum in the history of the state. So just to give a bit of background to the article 41.2, it's always been very controversial. So even before the Constitution's passage in 1937, it was subject to a lot of debate. So like women from like the suffragette movement and feminists at the time argued that it undermined women's right to work, and it said that it equated motherhood with womanhood. And the Republican Congress at the time called it a Stone Age conception of womanhood. And in 1937, there was a campaign by the women's worker unions, graduates and feminists calling for its deletion or amendment from the Constitution. But ultimately, the Constitution was passed by a slim majority, and the article has been part of the Constitution ever since. And then obviously, Ireland was quite a dark place for women for quite a long time. The country was basically a Catholic theocracy. I'm sure most of you already know this, but just to put it into perspective for anyone who doesn't know, divorce was only made legal in Ireland in 1995, and of course abortion was only legalised in 2018. So women having rights is a new thing in Ireland, really, but despite this, we've kind of positioned ourselves as this super liberal place that other countries should look up to and emulate. And this is basically the campaign message that all of the political parties ran for with this referendum. So it was as if this was like the final step for Ireland in shaking off its conservative Catholic past. For example, Fine Gael, who are in government at the moment, they ran ads, like campaign ads for this referendum using like clips, black and white clips of 1950s housewives and like women's rights activists. And the voiceovers were all this like really inspirational voiceovers talking about how the referendum was going to modernize Ireland and make it a more inclusive place. A huge player in the campaign was the National Women's Council. So they're our biggest women's NGO, and they're almost completely government funded, but you know, they're not pro-woman at all. they have a trans-identified man on the board, and in 2020 they were part of like an open letter that was signed by a lot of NGOs that demanded that women's rights groups who seek to defend biology, but in quotes, that's what it said. So basically radical feminist and gender critical feminist groups, they signed a letter saying that we should be denied political and media representation. So they're state funded, and they were like they ran the campaign for this referendum basically. And they did a stunt. They all dressed up in period costumes, and they did a historical recreation of a protest that women did against the article in 1937. It was just very embarrassing. There was no real substance to it or any explanation as to how this amendment was going to actually improve women's lives in any tangible way. So yeah, I think this is why the amendment ultimately failed. The government spent 20 million euro on this referendum, and it was like basically nothing more than virtue signaling how progressive we are as a country. Meanwhile, like the country's in bits. Their childcare costs here are the highest in Europe. Like I think it's 1,200 euro a month to keep a child in a creche here in Ireland. And like there's a huge housing and rental crisis. Like something like 70% of 25 to 29-year-olds still live with their parents. The amendment also drew like lots of criticism from disabled people and their carers, because the government's plan was to replace woman and mother with the term carers within a family. Many disabled people and their carers felt that the change would place the burden of caring for disabled on unpaid family members, which I mean it pretty much already is here in Ireland, but they saw that as a step back for their rights, because like they're looking for care from the state, and this was just further putting the care on the family. So there was also the argument that the existing article should be understood in a modern context to help women who need to stay at home. So for example, there's actually a Supreme Court case. It just started a couple of days ago, and this is going to examine the article for the first time in court. This case, it concerns a woman who is the mother of a disabled adult who needs 24-hour care, and she's not entitled to carers allowance, the full carers allowance, because her husband earns 800 euro a week or something like that. So yes, she's going to use that. She's using that article in the Supreme Court at the moment to try and get full carers allowance. So like that, just some of the reasons why people were campaigning, people voted against it. Another thing is that there's been a rise in right-wing immigration sentiment in Ireland, and that's a very recent development in the country. But there are just a lot of people who are angry at everything the government does, and just saw this as a total waste of resources it wasn't going to improve anyone's life. So yeah, there was just no appetite for this, and its failure pretty much showed that none of our mainstream political parties understand the electorate at all. Even the opposition parties campaigned for a yes vote. The no campaigns just came from a small but growing pro-life party called AU, the disability rights activists, Catholic organizations, and then some gender critical groups as well. So yeah, then pretty much immediately after they realized the referendum had failed by such a high margin, the very parties who had supported it were like, God damn, we really got this wrong. So within a matter of days, a number of politicians from the government party Fianna Fáil came out, and they admitted that they'd actually personally voted no despite canvassing for a yes vote. Like there was one TD, she was photographs of her out on the street with leaflets and stuff like that, canvassing for a yes vote, and then she admitted that she was against it the entire time. And then other Fianna Fáil TDs came out and said that they thought it was time that the country stops playing to the woke gallery. Sinn Féin, which is our largest opposition party, also backtracked on their support of the vote. And most significantly, our Taoiseach, that's the Prime Minister in Ireland, Leo Varadkar, he resigned with immediate effect less than 2 weeks after the results. He claimed it was for personal reasons, and I'm sure personal reasons did play a role, but this referendum was the most disastrous in the history of the state. So, I mean, I am sure that did play a role in his resignation. So for now, he's been replaced with a colleague, but opinion polls are not in Fine Gael's favour anymore, and this government is reaching the end of its tenure anyway. But I mean, hopefully there will be a general election before then. So I guess the question now is if the failure of this referendum will do anything to, halt or delay the other legislation in Ireland that is threatening women's rights. And I think the answer is possibly yes, particularly in the case of the hate speech legislation we have. So for anyone who doesn't know, we have a very extreme hate speech bill, which it's been held up for quite a while in our upper house, the Senate or the Senate. It's still in process, but it's a very dangerous bill. It doesn't even define hate. It outlines a very harsh punitive investigation process for those who are accused of hate speech against so-called protected characteristics, which of course will include gender identity. Critics say that the intention of this bill is to create a chilling effect on those who have dissenting opinions, which may cause offense. And it also criminalizes the possession of offensive material, such as books or memes, regardless of whether there is an intent to share it or not. And one of the worst things about this bill is that the burden of proof is reversed under this bill. So the onus will be on the accused to prove that they didn't intend to share this hateful material or spread hate. It's essentially legalizing thought crime. And some of the other worrying aspects of this bill are the power given to police and judges. District court judges will be allowed to issue warrants to any Garda for any home or premises where they suspect hate material is being prepared. And the police will also be allowed to demand any password necessary to access phones and computers. And those who refuse to provide the passwords will face 12 months in prison or fines of up to €5,000. So this process is really extreme, open to abuse and used to intimidate and punish people. And so it's just overall, it's a really worrying piece of legislation. And from other countries, we know this will be used to target feminists, women's rights activists, and our material. So we currently have a coalition government of 3 parties here, 2 centre-right parties and the Greens. But the largest party by support base is actually the opposition party, Sinn Féin. And if a general election is called, they are probably likely to win. But again, like the referendum, Sinn Féin supported this hate speech legislation. But in the past 2 weeks, they have come out and called for it to be scrapped, saying that it's badly out, not fit for purpose, and that it's clear it doesn't have support across the political spectrum. And politicians from the government party, Fianna Fáil, have also made similar comments. And another piece of legislation that is very concerning for women's rights at the moment here in Ireland is our health-assisted human reproduction bill. This will cover domestic and international surrogacy in Ireland for the first time, and it's by far the most liberal in Europe, and it's also a global first. Until now, no other country in the world has attempted to regulate the use of surrogacy in foreign countries by its own residents, but this one does, even though it's impossible to regulate surrogacy in jurisdictions that you have no control over. But anyway, the government claims that the bill is ethical and entirely altruistic in nature, and it insists that commercial surrogacy won't be allowed under the law. But comments from politicians and the bill's wording, it's clear that the bill will just legalise commercial surrogacy by stealth. Under the law, Irish residents will continue to travel abroad for surrogacy. They'll be allowed to apply to travel to any country, provided they show evidence that their surrogacy has no commercial element. And the government claims that this will ensure there's no exploitation happening. But I mean, I think this is ridiculous. Like, the government can't control what happens outside of its own jurisdiction. And as everyone knows, the international surrogacy industry is so corrupt, and they can't guarantee that the surrogate isn't being exploited or that the clinic she's in treats her ethically. The bill will also allow reasonable expenses to be paid to the surrogate. This will include all medical costs, travel, loss of income, clothing, childcare, housework, and all other expenses. Surrogacy lobby groups are also lobbying for the reasonable expenses to include the average wage of the country in which the surrogacy is taking place. So in the case of Ireland, the average wage here is €45,000, which the average woman who's taking part in the surrogacy arrangement does not have access to that type of wage. Like, to call this altruistic is just crazy. In the UK, where they already have this altruistic surrogacy is only altruistic surrogacy is legal in the UK. However, they also have this reasonable expenses framework in place in the UK at the moment. But yet the median payment to surrogates in the UK is £14,000, and 10% of surrogates get over £20,000. And usually it's paid monthly to surrogates throughout the pregnancy. It's not expenses. She's being paid. So this law will essentially legalise the trafficking of children across borders, and it says it's okay for newborn babies to be removed from their mothers at birth. And as of now, this bill has widespread support across all major parties. It's been spearheaded by a Fine Gael senator who herself actually had a child by surrogacy in 2015 in India. And this was just 1 year before India actually banned the practice altogether. Ireland has a very, very high rate of international surrogacy. We have the second highest rate of international surrogacy in the world. Surrogacy is very popular here for some reason. And there's zero criticism in Irish media practice, just because I guess so many well-known Irish people and so many wealthy Irish people use surrogates. So I mean, they just don't criticize it. But I'm thinking that maybe with the recent rejection of these referendums, that when the government sort of gets its act together and like the Dáil and the Seanad start working properly again, that perhaps more criticism of surrogacy may start to emerge. Yeah, so that's basically it for Ireland. Kind of a little bit hopeful that maybe things might start changing better. There's going to be a general election in the next year anyway, if there's not if there's one called more sooner. So
now we'll go to Joe Brew and Sally Wainwright.
I'm here with Sally Wainwright, who everybody knows. She's the WDI rep for Women's Declaration International for Scotland. And I'm going to ask Sally about the new hate crime laws, amongst other things. So, Sally, what's happening with this hate crime?
Well, actually, I think Gabriella was just talking about hate crime in Ireland as well. I didn't hear everything that was being said, but in 3 years ago now, the Scottish Government passed some legislation called the Hate Crime and Public Order Bill, which has just come into force on the 1st of April. And one of the reasons it's taken so long to come into force is because the police, amongst other people, have been saying it'd be really difficult to implement it. So previously, in Scottish legislation, if you committed an offence that was aggravated by racial hatred, then that would give you potentially a longer sentence if you were convicted. That was of a regular crime. And the Hate Crime and Public Order Bill did two things. One is
just an even loud.
Oh, sorry, can you hear me now?
Keep going, yeah.
Okay.
Really loud.
So one of the things is that the Hate Crime and Public Order Bill added a whole load of other aggravators to the legislation, so that if you commit an ordinary crime, but it's committed because of a whole load of prejudices, including on the basis of somebody's sexual orientation or on the basis of their gender identity, then that would again lead to a longer sentence. That's a bit worrying, but for that part of the bill, you have the act, you have to have actually committed something that in itself would be criminal. What the act also does is introduce a new crime of stirring up hatred, which could mean absolutely anything to anybody. So, I mean, clearly, if I go out and say, aren't these people horrible, you should go and shoot them, that would be stirring up hatred. But where the line is drawn before you get to that point is completely unclear to everybody, including, I think, the police. And that's the thing that's caused the greatest amount of concern. Sorry, we're in a very public space because there isn't anywhere really private, so apologies for the background noise. So that's caused the biggest concern, and it was clear that women, gender critical women, were going to be one of the targets of this legislation, that there was a real danger that as soon as we call the man a man and use male pronouns, that we could be accused of stirring up hatred. This new offence is stirring up hatred. So on the 1st of April, I have to say, J.K. Rowling came riding to the rescue. Some of you will have seen this. She did the most extraordinary series of tweets in which she named a whole load of men who pretend to be lesbians who are also convicted sexual offenders. And she called every single one of them a man and described what he'd done. And then said to the police, if this is stirring up hatred, come and get me, arrest me. And so within 48 hours, they had to say, no, we're not going to arrest her. What she said isn't a hate crime. So Justin herself, in that one series of tweets, she basically had the police admit that we could gender somebody correctly or sex somebody correctly without being accused of hate crime, which is, I think, a big relief to a lot of women. But there's still a lot of leeway, and nobody really knows what the situation is going to be like.
And is it true that J.K. Rowling has said that if a woman is accused of a hate crime or that the police are investigating her, J.K. will say the same thing?
Well, what she said is, if a woman is arrested for calling a man, I will repeat her words and they can arrest both of us. Because obviously, if I was arrested for something really extreme, she's not going to repeat that. Oh, I see. So what she said is, you know, if you call a man, I'll repeat the words, you can sue us, but you can charge us both at the same time. I mean, it is ridiculous that women in Scotland's sort of basic human rights are reliant on somebody with her sort of influence, if you like, and the ability to stand up to things. But the police did various other things at the same time. So one of the things they did was they ran a big campaign called Hate Hurts. And they've got these huge, enormous posters all around the country, and they've gone around schools and things. And they've also revised the notion of the hate monster, which is a kind of furry condom-shaped red thing with eyes, which is known as the hate monster. And the blurb goes, you know, you might be talking about somebody, and before you know it, you've committed a hate crime. Well, that's obviously ridiculous, because part of the legislation says that you have to do it deliberately. And a reasonable person has to think that it's a hate crime. So if you sort of say something in a sort of slightly drunken moment, that doesn't necessarily make it hate crime. So there's an awful lot of confusion and a lot of fear about what it will entail.
I heard that within the first couple of days, 8,000 hate crime incidents had been reported to the police, and that was something like 1 a minute. And that means that the police and they've promised to investigate every single hate crime incident. Is that, and so that's going to make it unworkable as well.
Well, there's an added complication, because the police have been recording things called non-crime hate incidents. So in other words, if I report you for having committed a hate crime, the definition of which is that I find what you said hateful, that's not got any sort of objective definition at that point, then they can record that I committed a non-crime hate incident, that it wasn't hate. Well, that's something that's being challenged in court now. And it's more or less illegal in England, but not in Scotland. And there were, as you say, 8,000. I think there's figures. The last time I heard, there was 10,000 hate crimes have been reported in the last week. It's absolutely ridiculous. But actually, when they looked at them, I think there's something like 300 that they've decided they actually are going to investigate, that the rest don't meet the criteria at all. So the whole point is that the thing's being weaponized, and it's unworkable as well, because if every time I stand up and let women speak rally or something and call a man, I'm going to be reported for a hate crime, the police are going to be inundated.
Yeah, and you were at the Let Women Speak rally, so I think everybody knows that run by or initiated by Kelly J. Keane, who incidentally has said she'll come on Feminist Question Time, but we're trying to set up a date. But she said hopefully she'll be able to come. But you were at the Let Women Speak rally in Scotland, and I saw your speech, which was fantastic. I've never seen you as angry before. You were
very measured.
It's about after about an hour. It's about an hour, and Sally gets up and it was. But how was that? How were the police? How were the demonstrators?
Well, it was interesting because we had been very concerned, just as women and not as organisers, that it wasn't going to be properly policed. The last time Kelly J was in Scotland, in Glasgow, it was very, very well policed. But a sort of local Scottish group has done some sort of smaller scale events. And in Aberdeen, and more recently, just a couple of weeks earlier in Dundee, when they'd been attacked and spat on and things. And I reported some bloke calling himself Sophie Sparkles because he had posted on Twitter, oh, I see Kelly J. Keane's coming to Scotland, perhaps she'd like some tomato soup. So that sounds anodyne enough in itself, but obviously if you know what happened in New Zealand when somebody poured tomato soup on top of her and there was extreme violence going on, that it was really trying to stir up both threatening and I think inciting violence. So I reported Sparkles for that. And the result was that 2 policemen came to my house to take a statement. So I spoke to them for about 3/4 of an hour, and really I was just trying to explain to them why we were in so frightened that it was going to turn really, really violent. And I showed them the videos from New Zealand. So, and I know other women have been speaking to them as well. So we were sort of hopeful. And they phoned me up. They kept phoning me up all week and told me that they'd got in a special contingent of public order police, and there was 3 bandloads of police going to be there, and there was going to be barriers, and it was all going to be marvellous. But actually, on the day, the trans activists were allowed to take over the space that had been designated for Kelly Jane King's rally, and we were crowded. The women were crowded into a smaller space, and you know, we described it as being kettled in because there was barriers all the way around it, which was supposed to keep us secure, but there wasn't a double barrier as there should have been. So that although even when women were inside the barriers, the trans activists could walk around the outside and be sort of like that close to the women with just a little metal fence between us, waving trans flags and anarchist flags, and people were quite frightened. I think a lot of people were quite frightened, and the police just didn't seem to do anything about it. But when the trans activists or protesters, the cabaret for hate, as I like to call them, who were performing and making an awful lot of noise, and when they objected to, well, Mr. Menno and another woman photographer went up close towards where they were speaking and tried to take photographs, and Menno was trying to have a bit of a conversation with them. And they sort of screamed for the police to remove these people, and the police laid hands on both of them and pushed them out of the way. And they didn't do anything remotely equivalent for the men who were upsetting the women. So I think there's been a lot of complaints about very biased policing, which there hasn't been a response to yet.
Yeah.
I think a lot of us put them in. And the other thing that a lot of us objected to was that there was 2, I think it was a man and a young woman, who were holding banners, one of which said, Dykes love trans tits, and the other one said, Dykes love girl dick, which, as a dyke myself, I can assure you is not true. And the police took no action against that. And again, a lot of people have reported them, including myself, for either for hate speech or again for, you know, promoting rape culture, because really that's what that's all about. I haven't had a reply to my complaint yet, but I have seen a response that somebody else got, which was along the lines of, oh, the police were aware of this at the time and it's not lesbophobic. So considering the hundreds of thousands of pounds that they've spent on being trained by Stonewall, they really ought to recognise lesbophobia when it's staring them in the face. So I think that's something we're going to have to take up.
And what about Scotland in the election coming up? Do you think that has there been a change in public opinion now after this ridiculous hate crime?
Well, something like 3/4 of the population thinks that the hate crime legislation should be abolished. It's just a farce. And also there has been an arrest. There was an older woman who was arrested. She was being harassed for years by her neighbour downstairs, or next door neighbour or something. And I think she'd made something like 40 complaints about harassment about the downstairs neighbour. And then the neighbour reported her for using a bad word. I don't know what it is, it's only reported as having started with an N, so you can fill in the rest of it. And the police turned up at her house and arrested her. And then, you know, sometime later they decided that no hate crime would be committed, and they released her. But it does mean that women are very, very vulnerable, because this woman, you know, she wasn't involved in anything. She was very, very shaken, I think, by it.
Yeah.
And we're in a situation now where we're getting training on what to do if you're arrested just for speaking. I mean, this is a ridiculous state of affairs. That here we are in Scotland, and every time I turn around, somebody else is doing a training or producing guidance on things, on what to do, what to say, what your rights are, when you don't have to go to the police station, when you do, what information you have to give them. And this is not because we're all about to go and start throwing bombs at anybody, but because we might stand up and say men can't be lesbians.
Yeah. That's terrible. What about the conversion therapy ban? Is that happening in Scotland?
Well, you would think with what has happened with CHAS and the English government saying that, or Rishi Sunak specifically saying that the conversion therapy bill in England is now dead in the water, fortunately, and then following the CAS review, you would think that the Scottish government would at least say, maybe we should have another look at this. But at the moment, it's not clear that's what they're doing, although there has been a bit of distancing in that at some point the government was saying, oh, well, it's nothing to do with us, it's up to the clinicians. And I know Joanna Cherry and Robin Harper, who was the first leader of the Greens when the Greens were a party worth voting for back in the day, they've written jointly to the chief medical officer, I think, or somebody like that, to ask them, because the equivalent of the Tavistock Clinic in Scotland is called the Sandyford. And the Sandyford still, for example, prescribing PBT blockers. And so they have written to them to say, you know, we think you need to look at this. Again, as far as I know, there hasn't been a reply yet. But it is really worrying that the Scottish government tends to say, Kira Bell, oh, that's English law. The CAS review, oh, that's England. As if somehow magically children, as they step foot over the border into Scotland, acquire a whole different set of characteristics and don't need to be protected, which is obviously bonkers. So I don't know what's going to happen with that. Obviously, there's a lot of pressure going to be put on them now to look at this again.
Yeah, and what's happening, is there anything coming up in the next few months in Scotland?
Well, the next thing that's due, I think, is the conversion therapy bill.
Yeah,
And I am sure there will have to be more conversations about the hate crime bill, but the hate crime act. But so far, there's no sign of movement on it.
I mean, a thing that I guess a lot of people here in the webinar will be thinking is it was quite encouraging how much ridicule was thrown at the Scottish government over this hate crime legislation, and how much support there is on our side. It does seem to be more and more people are hearing about it and prepared to stand up for it. So that's quite positive. So I think, have we got anything else to say, or should we hand back to?
No, unless there's any questions. I think
Yeah.
that's probably everything that's worth reporting at the moment.
I'll have a look and see if there's any questions, but we
I
think
didn't,
we're done.
I think the questions in the Q&A were answered.
Oh, fine.
Yeah.
Yeah. And so, and I didn't see any, haven't been following the chat exactly.
Yes, we think we're done then.
Yeah, I mean, there was a question in the chat that said, has it been established if we say lesbians don't do dick, that that will be recorded as a non-crime hate incident? But I don't think there's been any clarity on any of these sorts of things. They have had to say that calling a man, that they weren't going to report non-crime hate incidents against J.K. Rowling for what she said. So that should mean that they're going to struggle to report them as report us for these things if we call men. But as for the rest, it's all still to be seen what happens, I think.